Recording has begun again. All right, so the Constitution Study Group. Today we are going to, after a review, we're going to look at Article 3 of the Constitution. But we start with the review, and we review, the first thing we review is the definition of republic. Who wants to tell me what a republic is?
It's not a democracy.
That's correct.
A republic is a
Okay.
combination of the three natural forms of government, which are aristocracy, democracy, and monarchy. And it combines all of those forms, and it follows the rule of law.
Good. Okay. And it has a constitution which describes how those three branches are going to work together. Anything else, Howard?
Well, Aristotle wrote a book called The Republic long time ago.
Actually, it was Plato, but it was.
Excuse me. You're totally right. Did I say Aristotle? Did I say Aristotle?
Freudian slipped it. No.
No. I was reading something recently that it talked about Aristotle writing a rebuttal to the Republic, which I got to check that out.
If it is, it's his book, The Politics.
Oh, wow.
Politica.
Impressive. Well, I'll look into it and let you know, John.
Okay, because in that one, that's where he describes what a republic is, although being Greek, he did not know the Latin word republic, but he called it a constitutional polity, meaning that you have to have some kind of constitution, written or not, but agreements as to how the three branches are going to work together. And that's what makes it work is the Constitution that basically defines what the Republic is.
Wow, impressive.
What's that, Howard?
I said, wow, impressive, John. Very cool.
Okay. Well, I wrote a book about it.
Well, all right. Maybe you've done some research to achieve that, eh? What he had judges or people who watched. Did he not?
Well, the Greeks did.
I'm talking about Plato's Republic. He
Oh,
had a class of rulers. What did he call those?
Well, see, really, what the Republic was, what the book, The Republic, was a discussion of. It started out as, and basically was a discussion of what is justice, and how you define justice, and how do you achieve justice, and what's justice all about. And in that, then he started to. He went into then, well, what would be the perfect form of government? And he, of course, being a philosopher, decided that the best form of government would be one that was run by philosophers, because that's who he was. So, of course, it would be the perfect government. It was those run by philosophers. However, he recognized that that corruption would creep in, and they would no longer be striving after truth and beauty and the things that philosophers deal with, but it would kind of sink down into honor. And so it would devolve into what was called a timocracy. And I really don't know why they got that name that way, but it is in search of honor rather than being in search of truth and justice and beauty and that sort of thing. And then that would, of course, devolve into those that were rich were the ones that ran the government. And then that would devolve into a mob rule of a democracy. And then that would devolve into a single person rising up to restore order. And that was the way governments ran. And he wasn't saying that this is right or this was good. He was just saying this is the way they are. And Aristotle, who was Plato's student, wasn't real happy with that, and he wrote and by the way, the title of his work, the title of Plato's work was something like Politia, which meant the ideal the ideal relationship of an individual to the state. And it was a search for the ideal of the relationship. When Cicero, who was Latin, translated the Greek Politia, Plato's Politia, into Latin, he called it republic, because to Cicero, a republic was the ideal state between man and between a person and the state. So that's how it got the name republic. It was actually misnamed because it doesn't really describe what a republic is. And in fact, during it, Plato calls it, he says this form of government is an aristocracy. It's not, I mean, it's not anything else. It's an aristocracy. And then it devolves down into a democracy because just because of the way things are, and then it turns into a tyranny at the end because the mob starts to rule. So what Aristotle did is he said that's not really he didn't really argue against it. He was just describing this is the way it is, and he describes the natural forms of government, which, as Marty was mentioned, are aristocracy, monarchy, and democracy. A monarchy is a rule by one person, which we know is a valuable and viable form of government if you have a society that is
sane.
Well, no, actually what it is if it's a society that's all moving in the same direction. If they all want to have the same thing, like for instance, if you have a team that wants to win the football game, you're going to select out of it a monarch who's going to run the team, and that guy is called the coach. So the coach is the monarch, and it is a excellent form of government for that group. If you go to a war, you want to win the war, and everybody wants to win the war, so they choose the general that's going to be the guy that's in charge of it, and his word is law. And if he says, go attack over there, you go attack over there. The captain of a ship is the same thing. He's the one that's going to get you to land. And so if he says bail the boat, you bail the boat. If he says raise the sail, you raise the sail, because he knows what he's talking about, and everybody's got to follow his rule. But that only works if you have a group that everybody is all on the same page. You're all going the same way. And that's rule by one. The next one is an aristocracy, which is a rule by the few. And we have aristocracy all over the place today, because that's what families are. Family is generally, the traditional is a mom and a dad and, 8 kids or however many kids.
Exactly.
That's how many kids you have, Bob. Isn't that right, Bob?
That's close.
Close, okay.
I got 8 grandchildren.
8, yeah, I have 6 of them, exactly right.
Holy cow.
So if you put that up to a vote, what we're going to have for breakfast, you're going to have 6 votes for ice cream, and one vote for something nutritious and another vote for something nutritious. And if you have a democracy, it's going to be unhealthy. And if you attempt to have a monarchy, I can just see the dad trying to be a monarch in a regular American family today, or the mom. Either one of them doesn't matter. They have to have kind of shared responsibilities, and they both work together. So it's a rule by not the one person, but a few, the minority, who are better able to take care of things than they would than most people can. Or in this case, in the case of a family, you have 8 children, and 2 adults. The 8 children are not able really to take care of themselves, so the 2 adults who can take care of them do. And then the other form of government that Aristotle talked about was democracy, which is a rule by the many. So you have the rule by the one, which is a monarchy. You have a rule by the few, which is an aristocracy. And you have a rule by the many, which is a democracy. And that works fine if you have a population which every person is not only able to take care of themselves, but if they happen to do a wrong to somebody, they step on their toe or something like that, they're willing to say, excuse me, and make it right. And it will work in that kind of a situation. However, man is corruptible, we'll just put it that way. And that means that we can start out that way, but it's all too easy to get to have somebody not follow the rules. You have to have some mechanism for handling that. And each one of these forms of government, Aristotle knew and mentioned in his book. One of these forms of government is good for the type of society. If you have that kind of society, perfect for that kind of society. But if you don't have that kind of society, it will turn into the evil twin brother, and a monarchy will become a tyrant, a tyranny. An aristocracy will turn into an oligarchy, in which the few don't care for those who can't take care of themselves. They care only for themselves and cause problems amongst the others that they're supposed to be taking care of. And then for a democracy can also turn into a mob, which I think we're all familiar with, which is exactly why Steve said, well, republic, that's not a democracy. It's exactly right. It's not. So then Aristotle also recognized that there was another form of government, which was what he called a constitutional polity. And it is what later on the Latins called a republic. And it is a combination of all three types. A constitutional polity has one branch in it that is a monarchy. It has one branch in it that works on democratic principles. It has another branch in it that works on aristocratic principles. And these three branches have checks and balances to each other. They have definite definitions of defined roles. And in order to get anything done, they have to work together. And so they, and the point of that kind of government is it makes it so that if a monarch wants to turn into a tyrant, the other two branches will hold him off from doing that. If the democratic part wants to turn into a mob, the other two branches will hold him back from doing that. And it will, so those three branches will all work together. And it is designed for stability and individual liberty. And that is that's what its aim is. So, so when the founders, when they threw off the King of England and stuff, they said, well, what are we going to do? What kind of government are we going to have? And they decided upon a republic, a good choice, I believe. And in order to have a republic, they needed to come up with a constitution for the republic. And that constitution is what we today call the Constitution. It is that document. And that document describes what the three branches are and how those three branches work together. And so far, we have covered Article 1, which deals with the Congress, which is the democratic which is the democratic branch of the government. That's the one that has where majority rules. And whenever you have some law pass Congress, it has to pass by a majority vote. That's how you can tell that that's the democratic part of the government. And it has two branches to it. One of them is the people, which is the House of Representatives, and also the states. So that the states are represented and the people are represented. And each of them you have to have a majority of each of them in order for something to happen in the government. And that's Article 1. Article 1, we go through, we've gone through it section by section. It defines what the House of Representatives is. It defines what the Senate is in section 3, in section 4, 5, and 6. talks about setting up the Congress so it can work, about keeping a journal and that sort of thing. Section 7 talks about the procedure for making a law. Section 8, and that's the whole thing about that it has to pass one house, then it has to pass the other house, and then it has to go to the president, get signed, and all that stuff. And there's checks and balances all in that, all throughout all of that. Then Section 8 talks about the powers of Congress, because the states were creating this, and it actually wasn't the states, it was the people were creating this government. Because the people were creating this government, they said, we are only giving to this government certain powers. We're not giving to it everything. It can't do everything. It can only do the things that we tell it to do. It is our creature. We own it. We run it. And so Section 8 has the list of all of the things that it is granting Congress to do, which includes things like, copyrights in post offices and raising an army and all different kinds of stuff like that. Section 9 then talks about the powers which are absolutely forbidden from Congress. Congress cannot do these things. And Section 10 then talks about things that the states are not allowed to do either, because they're handing some of the powers over to the national government. So there are some powers that the states are not going to be allowed to do. So that's Article 1, and that defines what the Democratic branch of the government does. Then Article 2, which we just covered in our most recent meetings, it talks about the monarchical branch of government, which is the president and the executive, and it talks about all of the executive power is in the president. It says he's the one guy. So if something has to happen, he's the one that has to get it done. And that's how you know that that's the monarchy, because it's not a majority rule. He says, do it, it's got to get done. So you know that that's the monarchy part. That's why he's the commander in chief of the army, of the armed forces, because when you go to war, you want to have one guy in charge that runs the thing. When you want to execute laws, you want to have one guy that is in charge of executing the laws. Now, there are checks and balances between the other branches on making sure that he does it right and doesn't become a tyrant. But that's section. So anyway, that's Article 2. Then we get to Article 3, and Article 3 is where we're picking up today. So. Was that real fast, or everybody?
It was a great review, John.
I agree. I see that that's on page 19 in your book, What is a Republic, having to do with Aristotle Takes Another Look. I should read your book, John, so that I don't make foolish comments. But anyway.
Howard, it's okay. It's
Philosopher Kings. You even have that in there, and I was searching for that as Plato's class of people whom he thought best to rule.
Right.
So anyway, all right. Yeah. So.
All right. So,
I'm done.
So Steve, did I leave you in the dust?
No, sir.
Yeah. Okay, you're with me.
I'm
All
with
right.
you.
And Kevin, you're good. Okay. Good.
Thumbs up.
And Bob, you're smiling. I think you're still with me.
I'm with you, John, all the way.
Okay. And Marty, I don't need to ask. All right. So now I'm going to share my screen. This is my Constitution study guide. We're going to read from it. I have to find it here.
Gosh, no.
Okay. Oh, there it is. Okay, here we go. I have too many windows. I couldn't find it. All right, there we go. Everybody seeing
Almost.
Article 3, the judicial branch?
Not yet. There we are.
There it is.
Yes.
All right, good. All right, so as we usually do, I'm going to ask one of you to read, Bob, Steve, what we do. Oh, Steve has left the
Disappeared.
building. Uh-oh. All right, well, Marty, you're up. So
Okay.
what we will do is start reading the first paragraph. I don't know whether or not I'm going to stop you in the middle of it.
Okay. Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court.
Good,
And-
okay. So the judicial power, and we have to define what judicial means here. Oh my goodness, that reminds me what we need to do. Actually, excuse me, we're going to back up. We have to do some thing. We have to do the words first. Excuse me. So Marty, I'm going to have you, these are words that are found in in Article 3, which are not common. And so we're going to go ahead and take a look at those. Marty, go ahead and do the first one.
Okay, admiralty, the laws having to do with ships at sea.
Exactly right. And this began, that became particularly poignant about 500 years ago or so when they started doing shipping out to far lands, into the New World and all that, and people would invest in it, and then if the ship sank, then who has to pay? And what they did is they made then the ship be the equivalent of a person, so that you could sue the ship rather than suing a person. And that's how the admiralty laws came about to begin with. It's
Interesting.
corporate stuff. So,
But if the ship sank, how do you sue them?
well, yeah, what you do is
The company.
yeah, that's right. You sue the corporation that owns the ship
Okay.
for the ship,
Okay.
as though it's the ship. All right, so that's that. Steve, are you there? Can you see the screen?
I'm here, I'm looking at this video.
All right. Can you read appellate jurisdiction?
Person is not happy with the way this out. What a judicial jurisdiction.
I'm not hearing you very well, Steve. Are you speaking?
Oh, microphone covered? Sorry,
Okay.
I had the microphone covered.
Oh, yeah, that'll do it. Okay, would you read for us the definition of appellate jurisdiction?
Yeah, appellate comes from the word appeal. If a person is not happy with the way his case came out in the court of original jurisdiction, he can appeal it. To appeal it means to ask a higher court, one with appellate jurisdiction, to hear the case and decide if the lower court made the right decision.
Good. Everybody got that?
Yeah.
All righty. Bob, corruption of blood.
In 1787, when hereditary monarchs still ruled, it was a common practice that when a person was found guilty of treason, his entire family, his blood, was considered corrupt. The corrupt blood might be exiled, deprived of property, or even murdered. Corruption of blood in the days of hereditary monarchs made sense. Treason was one family attempting to take the throne away from another family. The winner of any struggle for the throne needed to utterly destroy the losing family or fear another struggle that they may not win.
Good. And so that's why they had corruption of blood. And we'll see how this gets mentioned in the Constitution in a moment or two. Kevin, you want to do the Court of the Exchequer?
may mispronounce this, the Exchequer collected the taxes and made payments on behalf of the British government.
Sort of like the Treasury Department.
Mhm.
Howard, equity?
All right, equity. Something that a person owns or has a right to. A legal case, quote, in equity, unquote, is a case that has to do with ownership of property. A case, quote, in law, unquote, has to do with violations of law. Another term, chiefly British, for a court of equity is chancery.
Right. Exactly
Wow.
right. So you see, there's two different kinds of legal systems actually from Britain. There's two different types of legal systems. There's statutory, if you broke a law, and then there's having to do with property in chancery, and that's where the common law gets made. Common law has everything to do with my cow wanders into your field and you milk it. Is it my milk or is it your milk? You know, and all of the damage that my cow did to your field, who do I have to pay for it or not? That kind of stuff. That's all equity stuff. The next one is, I think I'll just go ahead and do the next one.
Does common law apply to the nobles, John, in England?
Don't know. They may have had their own. I don't know.
Okay, I'll try to search that out.
Yeah, that'd be nice. That'd be nice. Thank you. And then I will talk about original jurisdiction. Is a court with original jurisdiction is the court that hears the case first. That's the one that you go to first, and you say, I want that. I want to take this guy to court. All right. We good with the definitions? We're going to go on now to Article 3. How's that sound?
Good.
All right. And Marty had started reading this, but we'll go ahead and have you start reading it again.
Okay, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish.
Good. Okay. So the judicial power, first we have to define what judicial power is, and that is, as I say on the note on the side, it's the power to hear and judge cases. It's the power to judge what is going on. And they had, every time you have a group of people get together, there's going to be a possibility that somebody's going to break a law one way or another, or break some kind of agreement, and somebody has to decide what the penalty is going to be. Somebody has to decide whether or not the guy really did break the law. Somebody's going to have to decide that, and that is the judicial power, is having the power to do that. And it goes all the way back to the Greeks, all the way. Every civilization that has ever been has had to have some kind of judicial power. Quite often it was the king who was the ultimate judicial power. However, in this case, we're saying, no. We're not going to have the king be the judicial power. The judicial power is vested in the Supreme Court, and the Supreme Court is how we're going to do it. And since we don't know how things are going to look, how the country's going to grow, how we're going to do this, we know we're going to have inferior courts, because we cannot have every case that ever comes up has to go directly to the Supreme Court. That's just like crazy. You can't do that. So there are going to have to be inferior courts. And so they're going to leave it up to Congress to determine and establish what those inferior courts are going to be. I know that there have been examples. I know that there have been, I don't know if it's rumors or if there was actually an example where the Congress got really unhappy with the way some court was handling something, and they just basically passed a law that said that court doesn't exist anymore, and gave the powers of that court over to some other court. They changed. It's like right now we have various districts you know, and circuits. So you have the Supreme Court, and then you have circuit courts. You know, the Ninth Circuit is over California and the West Coast, and the Fifth Circuit is over, I think, Atlanta and Georgia and that area. But Congress could say, you know, it's possible. They won't, but it's possible that Congress could say, we don't like the way the Ninth Circuit is handling things. Call the Ninth Circuit and take the 8th and the 7th and split up, and all of the stuff that's now in the 9th, turn it into the 8th and the 7th, and just get rid of the Ninth Circuit if they wanted to. They could. Yes, Marty?
Two things. One, can you click on the little arrow on to get rid of the side stuff so that it makes the text bigger?
Sorry.
Thank you. And the other thing is, thank you, that's much better. Invested in one Supreme Court, and you notice that Supreme is not capitalized.
Correct.
So it's not like a Supreme, because it's always capitalized nowadays.
Right. Yes, because it's called the Supreme Court.
Right.
Right. And you're right. It is one Supreme Court. It is one court that is supreme over all the others.
Cool.
And the Congress makes establishes the inferior courts. Mm-hmm. All right. Now, Steve, would you like to read the rest of that paragraph?
Section 2.
The judges.
Middle of section 1.
It's I'm going to mark it right
First
here.
paragraph, third line. Oh, I see it. Okay. All right. Yeah, the judges, women and courts, shall hold their offices during good behavior, and shall at stated times receive for their services compensation, which shall not be diminished during their continuance in office.
Good. Good. Okay. So now many people think that judges hold that when you appoint a judge, it's for life, which is not the case.
Right.
It is during time of good behavior. Because as we have discovered in Article 1, the House of Representatives has the power of impeachment, and the Senate has the power to try the impeachment, and if they find that the person has done bad things and so on, then they can kick him out of office. So if the judge is not, the judge is only in there during good behavior. If he has bad behavior, he can be impeached and convicted and thrown out of office. It is not for life. And the Senate, or the Senate, the House of Representatives, the Senate, the Congress has, that's a check and balance on the court, is they can throw somebody out. They receive for their services a compensation. And now I ask, it shall not be diminished during their continuance in office. And why not, do you think? Anybody?
They want the judiciary to be independent, not kowtowing to the legislature.
Right. And not looking over their shoulders and afraid. That's exactly right. Not afraid that they're going to get a pay cut if they don't do what the legislature likes. Exactly right. All right, Bob, start reading section 2. I don't know how far you're going to get now. I'll probably stop you at some point.
Okay. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority.
Okay, that's good. Thank you. So the judicial power, both law and equity. So we're not going to have a separate chancery. We're not going to have a separate admiralty courts. We're not going to have separate this courts or those courts, and some for the common law and some for this and some for that. It's all under the Supreme Court. However, it has only to do with the things that are under this Constitution, the laws of the United States, and treaties made, or which shall be made, under the authority of the United States. It does not have the power to deal with things in state courts Although what has happened is that if you have something that happens in a state court that affects constitutional rights of a person, then that person will appeal to the United States courts because they'll say my rights as a U.S. citizen have been abridged, and this is part of the checks and balances between the two different levels of government. You have the national government and you have the state governments, and this makes sure that this keeps the two of them kind of in alignment. They can do that. However, it is originally suggested and originally intended that the judicial power is going to be under the Constitution, or the laws of the United States, or treaties made under the United States. They do not adjudicate state laws, but we except as I said, when it has to do with rights, then you end up going to federal courts, because that's where they can be adjudicated, because that's then something that's arising under this Constitution. Does that make sense, or did I just make it all muddy?
No, it's good. I have a comment, or maybe a question.
Okay.
Back in the mid-'80s, I ran across a group of people who were talking. Their thesis was that the federal government all had to do with admiralty law, and the law that was applicable to the people was common law. And since since we are citizens and not subjects, we have great powers to object to unjust laws. And one of the things they were objecting to was income tax. One of the speakers at this meeting I attended wrote a book called The Law That Never Was. And his contention was that because the last state to ratify the 16th Amendment, the Income Tax Amendment, did not go through the proper filings of forms and documents, that the income tax is illegal. And certification was a phone call from the governor of that state to, I believe, the Secretary of State of the United States at that time. Does this ring a bell for anybody about anything, or is it just my misunderstood or misapprehension of what was being discussed?
John's gone to his bookshelf.
You're talking about this book right here.
Yes, I am. I need to get a copy of that.
Yeah.
Yo, John.
I am familiar with that. Excuse me. Trying to put it back.
Just don't pay any attention
Put it back
to
in my
it, though.
bookshelf. Sorry, I am familiar with that. That is saying that not only was the last state that ratified it bogus, but it also says that more than that state were bogus, and there's a number of people that are still arguing with that and fighting on that and so on. And I ran into it in the 70s,
Sure.
and at the time I studied it pretty thoroughly, probably not completely thoroughly, but pretty thoroughly. And I knew a number of people that were in that movement. And I looked at it as close enough that I said, they're probably right, but I have to make a decision now. I have to decide if I am going to pursue
got
this.
it too.
And look at that. Bob has it too.
You have two copies, it looks like.
Steve has it too. Good for
Damn.
you guys.
I gotta
Have
buy
you
my
all read it?
copy now. You guys are ahead of me
Oh.
here.
So, yes, and it comes in 2 volumes.
Oh,
Holy
that's it.
cow.
So,
We have 2 volume ones.
what's that?
2 volume ones.
They got 2 volume ones.
Oh, you got 2 volume ones. Okay. Well, that's interesting because I got volume 2. I know where I can get volume 1, but I just never have gotten it. So, because I read volume 2 and I see what it is, and I go, well, volume 1 probably isn't a whole lot different. And basically, what it is it's saying that the procedures that were used in the states in a number of the states was flawed, and that therefore the
Passage.
application of it is incorrect, and so therefore it's not really a thing. So I looked at this and I had to make a decision, and my decision was they're probably right, and I could spend I could argue for this. I could work for this. I could do this. I could show that it's right. I could show that it's true. But I have to decide that I'm going to make it my career.
Yeah.
Because if I do start doing that, then I am going to be attacked for all different kinds of things. I knew a fellow who was doing that, and he would win on this thing, but then suddenly he would find the city is after him because he's got some kind of a quote problem with his water bill or something, and then he would straighten that out, and then he'd have some kind of a problem with something else, and then he'd have some kind of licensing problem with his business, and so I realized that if I was going to pursue that, I was going to have to make it into a career, and I decided that I would rather not make it into a career. And so I decided not to do that. Instead, I'm doing this and just teaching people and running across people like Steve that has 2 volume ones. That's so good.
Here's the real question, John. Did you decide not to pay taxes?
Got him to sign.
Oh,
They've signed books. The authors.
signed books. Oh, good. Oh, how neat. How neat. I pay the taxes that I will not get in trouble for, because I do not make it a career.
Yeah.
Now, I
My
do know,
man.
I mean, I know, because I've heard other stories about people former revenue agents that have done the proper paperwork, and that they have now declared they're this or they're that and so on and so forth, and they end up not having to pay taxes at all. And I go, it's just not worth my while. I would rather spend my time doing the things that I like to do and make more money than they can take away from me.
Yeah.
That's what I'd rather do.
Okay. Good.
So does that answer your question, Bob?
Yes.
Okay.
It gives me a context.
And I have a very good accountant.
That's the real key. That's the key right there.
Yeah, it is. It is. Finding things that you wouldn't find otherwise. All right. So, all right, Howard,
Yes, sir.
did we answer your?
Yes, that put it very much in a context. I know somebody who fought it, actually got put in jail for a night, and agreed as condition of release that he would file his
Extra return.
income taxes, but before he got around to actually filing them, he got a letter from exemption from the IRS.
There you go.
And whenever
Okay.
he was asked about that again, he would display the letter. Holy cow.
All right. All right, let's move on. I'd like to get through section 2. I'd actually like to get through this whole article here, if we can.
To all cases.
Yes, so it's this to all cases. I don't know who's reading. Steve, are you reading?
No, I was reading.
Oh, Bob, okay.
To all cases affecting ambassadors, other public ministers, and consuls.
Now, so the Supreme Court and federal courts are going to take care of that, because you don't want to have state courts getting in there. These are ambassadors and other public ministers and consuls who are representing some country to the United States. So you don't want to have some state coming in and saying, hey, you got a parking ticket, that kind of thing.
Okay.
All right, next one. To
To
also,
all cases of admiralty and maritime jurisdiction,
good.
to
Continue.
controversies to which the United States shall be a party,
Yep,
to controversies between two or more states,
yep,
between a state and a citizen of another state,
yes. Now that was changed by the 11th Amendment. That got removed, and when we get to the 11th Amendment, we can talk about why.
okay,
Okay.
between citizens of different states,
Yep,
between citizens of the same state claiming lands under grants of different states, and
right.
between a state or the citizens thereof and a foreign state's citizens or subjects.
Right, because you don't want to have a state going out there suing Spain. It has to go through a federal court.
Um,
So that's the jurisdiction, yes. Yes, Howard?
I wonder if you could read that to all cases of to cases regarding ambassadors.
Affecting ambassadors.
Oh, there it is. To all cases, ambassadors and other public ministers and councils. This would seem to me to apply to federal agents like the United States ambassador to England or
That's definitely an ambassador.
Yeah.
Also, though, if you have the German ambassador is here and gets charged with drunk driving. Not going to go to a state court for that. Has to go to the federal judiciary because he's an ambassador.
Well, there was a case not too long ago where the wife of a U.S. ambassador to England was drunk driving and driving on the wrong side of the road and had an accident, killed somebody, and man, she was out of that country like next day to
right.
avoid prosecution because she wouldn't have some sort of sovereign immunity.
Yes, that's right. It was sovereign immunity, and they got her out of there because she was persona non grata. You no kidding. Absolutely.
Yeah, really.
Okay, so now we go to the next.
What was their reasoning for that? Because that's criminal. If
No,
somebody,
the reason for that is because you don't want to have trumped up charges. We don't want to
well,
have.
if she actually killed somebody, that's not a trumped up charge.
But
Didn't she be responsible?
but much more of greater importance, I think, is maintaining relations with the country and having relations like that.
Okay.
Instead of having it dragged through, And I can see the other way. I can see it the other way as well.
Okay.
Okay, so now the next section. Are we okay to move on to the next section?
Yeah.
Okay. Marty, I can tell you're not happy.
I just hate people getting away with murder,
Dealt with them in other ways.
It's reciprocal, Marty. The British ambassador's wife kills somebody in the U.S. She doesn't get prosecuted.
Yes, she got away with murder.
Yeah.
That's not okay. I just don't think it's okay. Anyway.
Interestingly,
All
all right, I'll stop.
Yeah, no, I think that when she got back here, that she might have been charged with murder over here.
What are we talking about?
Wrong venue.
Who?
Yeah, I remember the case, but I don't remember. I remember the case, but I don't remember who it was specifically.
Oh, I thought you were talking about Hillary.
Okay, we're not political, so that's good.
Next.
Okay, that's fine. Thank you, Steve. All right, next, the next one here is who's reading next?
Kevin, I think.
Kevin.
Okay.
This one right here.
In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction.
Okay,
All
so
the-
go ahead.
In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make.
There's two important points in this. One is that there are some cases that can go straight to the Supreme Court, and no others can do that. And the second one is that Congress regulates what the court's jurisdiction is and what they can and cannot look at. That's what this part is right here. And if we say, what this means is that if the court starts making decisions based on international laws or something that aren't treaties, whatever, that Congress can say you're not allowed to look at those things.
So they lose their appellate jurisdiction over that topic.
Well, they have appellate. Well, but if they start saying, well, we like the decision that the court in Germany made, and so we're going to follow the court in Germany, their law. And Congress, they can do that right now. But if Congress came in and said, no, you're not allowed to do that, you have to deal only with U.S. law, then that would be a regulation that Congress could make.
So the Congress could nullify a Supreme Court decision.
It's not so much that they nullify the decision, they say you can't do that anymore.
Okay, so I wish they would step up to the plate, kind of do that.
I know, and there are a lot of people who wish that, and in fact, Mark Levin has even said that he wants a constitutional amendment that says that the Congress can overrule court decisions. And my point is, it's already there.
It's already there.
This is it. It's right here, and Mark Levin needs to read the Constitution.
Yeah.
Oh, I agree with that. I think the last time historically that Congress did this was 1874. I read that somewhere.
Okay, I'm not familiar with that. I don't know.
Okay.
And the other thing of interest at this point, I realize it's already 5 o'clock and we're getting on to. Okay, I want to get through this fairly quickly, but I do want to make one point of interest is this one right here. In all cases affecting that this original jurisdiction one right here is the case of Marbury versus Madison turned on this particular phrase right here. And in Marbury versus Madison, rather than going into the specifics of the case, the court spent a tremendous amount of verbiage in its decision on basically, in order for us to uphold the Constitution and apply the Constitution, we have to be able to read the Constitution and therefore, quote, interpret, discover what the Constitution means. And that was the case of Marbury versus Madison in 1803. And it turned on this particular one because Marbury brought his case to the Supreme Court as original jurisdiction, but he was not an ambassador, public minister, counsel. He was not a state named as a party. The state was not named as a party. So the Supreme Court was not the point of the original jurisdiction. So the Supreme Court said, because of the Constitution, we can't take this case. And they spent a great deal of time saying that they had to have the power to read the Constitution. And because a law had been passed saying that in Marbury's situation, he could bring it. Marbury wasn't mentioned specifically, but that he could bring the case to the Supreme Court as original jurisdiction. And the court at that point said, no, that law is wrong because this is what the Constitution says. So the law is wrong, and it voided the law because it failed to follow the Constitution. Now, all that it really does is it says, we, the judiciary, are not going to enforce that law. We're not going to allow that law to be enforced. So if you bring somebody here and he's guilty of a crime, and we look at that crime and we look at that law and we see that it's a law that shouldn't be, we're going to let the guy go. So you might as well not even arrest them. And they are then considered the final arbiter of what the Constitution means, but that's not really true. because we are the people, we're the ones that wrote it, we're the ones that own it, we're the ones that run it. We are the final arbiters, but the court is the final arbiter as to who is going to go to jail. That's how they're the final arbiter. They're not the final arbiter of what the Constitution means. That's us.
Well, the court, I believe, thinks it is the ultimate arbiter and
that's because,
granted itself that power under
because-
Marbury v. Madison.
and that's because we have allowed it to happen.
Right.
Now, the one thing is that the courts issue opinions. They do not issue rules or
Right.
laws. They do not rule on things. They issue opinions.
Yep.
And those opinions are then supposed to be evaluated by Congress as if they're right, I guess. I don't know, but they're just opinions.
What that opinion means is that if you come to us with this kind of situation again, we're going to make the same kind of decision and we're going to let the guy go. So don't even try. That's what the opinion is. That's the value of the opinion, because it only it's only binding on the courts. And then since the executive knows that if they want to send somebody to jail, they have to go through the courts, it's then binding on the executive and on the Congress to that degree that they know that the court is not going to put somebody in jail for it. I don't know if I'm making sense or not. Am I making sense on that or not?
Well, it's like like Roe v. Wade. It's an opinion, and it was for one particular case. But now it's like the law of the land.
Precedent.
It's not. That's not. It's an opinion on that one case.
And what is
You're saying that other people, that's just telling other people, don't even try because they're going to get the same opinion.
That's right. So that if then the state,
But that
so
Dred
then-
Scott would still be the same. It would still be there. The Japanese internment camp would still be, it's like, well, that thing is still there, I think. But, there's things that have to be gotten rid of because they're not constitutional.
Right. Right.
Well,
Right. But
your
that's up to us.
segregation was constitutional for the longest of time.
Well, it was, that's because of an opinion of the court.
Yes.
Right. So, okay, can we move on?
Sure, go ahead.
All right.
Well, I want to say one thing to Marty. There was a court case. The Indians sued President Jackson for removing them and putting them in Oklahoma. They wanted their original lands back. And the Supreme Court ruled with the Indians. And Jackson famously said, Marshall has made his opinion. Now let him enforce it.
That's right. That's
Yeah.
right.
That's all.
Okay.
Okay. All right. The next one is, I don't even remember where we are. Kevin?
I think the last one, the trial of all crimes.
Yeah, the trial. No, I read.
Oh.
Who's reading? Kevin?
Howard.
Howard?
Did Kevin
What?
read?
Kevin?
It's my turn. Let me read.
Yes, you do. Okay, right.
Are we
go
on
ahead.
trial by jury here?
Wait a minute, were
Yes,
we in
sir.
the middle of, yeah.
No, you're right. Trial by jury.
Okay, the trial of all crimes, except in cases of impeachment, shall be by jury, and such trials shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at the place or places as the Congress may by law have directed.
Good. Basically, it's trial by jury. It's kind of the beginning and seeing that we're going to have some kind of a Bill of Rights, and the trial by jury is enshrined right there.
So let's say that a murder is committed on a cruise ship. Congress has decided where that case will be tried?
Yep.
Question mark.
Yeah, I imagine so.
Okay.
I don't know specifically, but I imagine so.
Okay.
All right. Everybody good with what we got?
Yep.
Yeah.
All right. How you doing, Steve?
Fine.
Okay, good. Are we having fun yet?
Yes.
Absolutely.
Marvelous time.
No, I'm asking Steve.
Oh, sorry.
I'm always having.
You don't care about me.
No, I don't, Howard.
Okay, all right. Now I know
Steve,
where I stand
are you
around
doing
here.
all right over there?
Yeah, Steve's always having fun.
Okay, good, good. All right. All right. Article 3, Section 3 has to do with treason. And Marty, I think you can read that whole first paragraph there.
Okay, treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or to confession in open court.
Good. So the founders were, of course, very sensitive to treason because they had just committed it. And
Oh, great.
and so they were going to define, and treason against the king was pretty, the king could just decide, I don't like the Duke of York, boy, and you had treason and you wiped out the whole family and all the rest of that stuff. So they had to define what treason was. So that is levying war against the United States or adhering to their enemies, giving them aid and comfort.
Can I ask a question?
Yes, sir.
Isn't fomenting a revolution treason?
No, not quite. And that's very interesting because I happened to look that up today. Somebody asked me a question about that. In fact, that very much that exact question. And there is a statute which is called advocating for the overthrow of the government. And I had it. It's in Title 10 of the U.S. Code, which goes to your question of fomenting a revolution. But that's not treason. And the reason that it's not treason was because in the original treason trial of Aaron Burr, who was the vice president of the United States, he was accused of treason because he was plotting to overthrow the government. However, no evidence was found that he had actually levied war. He had not picked up a musket. He had not given the enemy any aid or comfort. He had not done those things, but he had fomented this revolution. So, of course, his political aspirations were gone. That was the end of his career. But he was not convicted of treason, but he most certainly would have been convicted of had that statute been in place. It's Title 10. I just wrote it. It's in an email. Sorry, guys. Okay.
I have a question.
But at any rate, that is something that can be called, and also then if you do have somebody that's fomenting a revolution like that and is actually looting and rioting, the president can invoke the Insurrection Act as well,
Right.
which was also originally passed because of Aaron Burr as well. Aaron Burr did a lot.
Got around. Quite a guy.
Okay, yes, Howard.
Did Jane Fonda commit treason when she gave aid and comfort to the North Vietnamese sitting in that
I don't know.
anti-aircraft gun?
I don't know. That could be. That's possible. That could be. Possible.
I don't believe she was ever charged. It would have been interesting if she had.
Yeah, no, I don't think she ever was either. Okay, but a person, and then it goes not only into defining what treason is, it defines what you have to have. What is the level of evidence that you have to convict of treason, which is two witnesses to the same overt act. He actually pulled out a musket. He didn't just write a letter saying, we really should overthrow the government. He actually did something, or to confession in open court. The last one here is, I forget who's up. Who's up for reading?
Marty?
Congress shall have the power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attained.
Right. So So,
Tainted.
attainted, yeah. And a bill of attainder is a document that says this guy's a bad guy, he did bad things. So if an attainder of treason is written against someone, it cannot work to corruption of blood, cannot deal with the children, the brothers, the uncles, the nieces, the nephews of that person. It's only for that person. That person is the one that committed it. And any forfeiture, any a payment of fines or any other penalty can only work during the life of that person. So they wanted to make real sure you didn't do like the king used to do to the Duke of York or whatever.
Okay.
Okay?
I want to comment that this is quite an advancement of individual rights here, this corruption of blood thing.
Yep.
That's quite a
Yeah.
great giant step forward.
That's
Yeah.
Thank you. I think so too.
Well,
And it's because we recognize that we are a country that's run by the people. We're going to govern ourselves. We don't have kings, we don't have entitled nobility and that sort of thing. So there we go.
interesting.
That's Article 3, which is basically the aristocratic branch of government. In an aristocracy, you have the rule of a few, which is the judge, the lawyers. They have specialized knowledge, and they use it to protect the little guy, those who cannot protect themselves. That's the idea. That's the way it's supposed to work. So that's Article 3, the aristocratic branch of government. Any questions? Because I'm ready to wrap it up.
I'm good.
Going once, going twice. Thank you. Howard's good. If Howard's good,
I have a question.
yes, sir.
Now, when you see people like Maxine Waters telling people to get in the face of Trump supporters and other people like her doing
Officials of government.
yeah, isn't that fomenting revolution? Because we're
Not-
getting a lot of this these people doing just what she said to do.
Well, it's despicable. However, she was saying there are particular people who are doing particular things that you need to. It's not again. It wasn't against the government. It was against particular people who were doing things that she didn't like. And she didn't say cause them bodily harm.
She's called to kill the president.
These guys, as I was asked this morning in an email about this exact kind of subject here, and that person was talking about Ilhan Omar and others like that who are saying that they want to, bring down the country and that sort of thing. From what I've seen, and I haven't seen everything, but from what I've seen, these guys are very, very careful to go right up to the line.
Not cross it.
And not cross it. And they're not stupid people. So I find it deplorable. I find it deplorable.
Real deplorables.
Real deplorable. And the and I have no answer to it except that we will outshine them.
And the way to defeat them is to get out, vote them out. Just keep getting rid of them.
All we can do.
Steve, what were you going to say?
No, I'm saying that's all we can do is vote them out.
Yeah, at this point, and also we can also watch and make sure that the election is not rigged and that sort of thing.
Stolen.
All right.
They're going to do all they can to do it.
All right. So anybody have anything else to say? Because I'm ready to end it off. thank you very much for being here,
Thank you.
and we'll see you next week.
Thank
Kevin?
you.
Okey doke.
Okay. All right,
Bye.
Steve. Glad you came. Hope to
Bye,
see you
Marty.
next
Bye,
week.
everybody.
Okay.
Bye.
Bye-bye.
Bye-bye.